I'm Mark Wesbrooks. I'm the author of the Debt Relief Playbook, How to Defeat Creditors and Win the Collection War. I wrote the Debt Relief Playbook after 23 years of law practice, after representing over 6,000 clients in debt relief and bankruptcy matters. I had learned over the course of many years that debt collectors will typically fight those cases that are easy to win, and that if a consumer were to raise valid defenses, that quite often a collection matter will simply go away where everyone walks away. That's typically what I do. If someone comes into my office with a debt case, I'm going to look at that right away. Are there defenses? Is the debt too old? Did they violate federal or state law in their efforts in trying to collect these debts? I'll look over the letters. I'll interview my client about phone calls, anything of that nature. Sometimes listen to the voicemails left on their cell phones. Well, there was a study that caught my attention. The study was done by a group of lawyers in the state of New York. And in that study, through that public interest law group, they selected somewhere around 3,000 court cases that had resulted in default judgments. In other words, a default judgment is where the lawsuit is filed, the defendant is served, and they're told by a summons, or what they call a citation, you have so much time to file an answer to the suit, and the defendant fails to file an answer, so the creditor's lawyer simply takes a judgment to the judge, and by default, the court grants the judgment. What was interesting was that out of all of the debt collection cases that were reviewed in this study, 91% of those cases were default judgments. Now, that's probably the same percentage of default judgments that I see when people come into my law firm. If they have a judgment, normally, if they did try to hire an attorney, they went to that attorney, the attorney said, well, it's going to be an hourly fee. We can't do a percentage or a contingent fee on a case where we're not expecting you to collect money, so you'll have to pay for the hours involved. So they get a retainer quoted $2,500 or sometimes more. And many of these debt lawsuits, they're $3,000 or $4,000 per claim. So a great number, I think, of these defendants that end up getting default judgments simply didn't have an option to hire an attorney. Or if they tried to do so, it just was not cost effective to do that. I also see people in my office who say they never even knew about the lawsuit, that the first time they heard about it was when they actually learned there was a default judgment. Maybe their employer got a garnishment order to suddenly start taking out a percentage of their paycheck. Well, I tell clients there are some dishonest process servers out there. They may not have actually served you with notice, but yet they filed something with the court that led the court to believe you were notified. So we talk about how to set aside that default judgment, and where we end up is more attorney fees, and when you set it aside, you still have to defend the case and win it. So what I learned, though, is that there is a large group of consumers in society who simply have no ability to properly defend these cases, and there's such a huge number of default judgments that are taken in courts and lead to wage garnishments and asset seizures that it's just something that is completely unjust and unfair. That same group in New York of lawyers determined that 1 out of 3 of those cases that resulted in default judgments had valid defenses. Either the debt was too old, or there was some valid defense that could have been asserted against that lawsuit. I know one defense I always raise is we hold them to their proof. We require that they prove, where's the document that I signed? Where's a copy of the consumer disclosures that were provided to me? Well, if the debt is being pursued by someone who purchased the debt, they're a debt buyer and they bought that debt as part of a bundle from a creditor, they're not going to have that information. So I felt over the years, I felt pretty satisfied that I could defend a debt case and make most of these cases go away. But what troubled me was that most of the people I see who have these defenses, they just can't economically afford to hire the attorney. So that's why I wrote the Debt Relief Playbook. The idea was to arm the consumer on how to defend a collection case, basically at 3 levels. At the first level, let's undertake some action, write some letters, let's do some things to get some information into that collection file that would discourage any creditor from bringing a lawsuit or their lawyer from taking the case, and might even discourage the debt buyer from even wanting to purchase that debt from a creditor. So if we can make it go away before it ever hits the courthouse, that's always the number one objective. So that's the first part of my book. The Debt Relief Playbook covers taking preemptive action. And I use that word preemptive. Some people have heard about preemptive strikes in wars, that if that first party can take an action, it can lead them to an advantage so that there never is a war. So I have sample letters in the Debt Relief Playbook. I call it the war chest at the back of the book. Gives several levels of these letters. One designed to back the debt collector up at the first instance, that they violated the Fair Debt Collection Practices Act. The idea is catch them in the violations, write the preemptive letters, and what will happen is that letter will suddenly be included in that debt collection file. So when the next step happens and it goes to the attorney's office, a different type of conversation is going to take place than if the only thing that was there was a debt and expectation that the lawyer will get a default judgment. So the conversation generally goes like this. Lawyer looks at a file, and lawyers have employees, they have families to feed. So the lawyer looks at the file and says, okay, this is a simple debt collection matter on a credit card. It is a cookie cutter petition or complaint that I file every day in other lawsuits. It's not going to take a lot of time. 91% chance the defendant will never answer. I'll get a default judgment. So they charge relatively competitive fees. They might charge 2 to 3 hours, 4 hours of time to that debt collector, because after all, that debt collector is bringing that lawyer a lot of files. Okay. Some lawyers, though, will take cases on what they call a contingency fee. So let's say it's a larger debt. Let's say it's a $15,000 debt or $20,000 debt. The lawyer might say, you know, I'll do the work on this, and I'll charge a 1/3 contingent fee. I can potentially make more earnings if this goes by way of default judgment. A few hours involved, I'll do that. Well, if the lawyer gets a file and the file has letters from the consumer that basically say, if you sue me, I will be filing a counterclaim and I will be pursuing damages under these federal laws, Truth in Lending Act, Fair Credit Reporting Act, Fair Debt Collection Practices Act. Those are all in the book. Well, that lawyer's going to have a different type of thought process. First of all, a lawyer would not want to take a contingency fee on a case where even if the lawyer's client prevailed, the other side is going to get a damage claim and they might offset or wash out, because after all, 40% of 0 is 0. So the lawyer then is going to say, okay, on this particular file, there's going to be a considerable number of hours. Now the conversation that takes place may be, I need to charge a 10 to 15 hour retainer. So now they're asking for a 2 to 3 or 4,000 or more money up front from the debt collector. Well, my experience is that debt collectors might do a fair evaluation at that point before they spend money on a lawyer. They know if they spend that money, and even if they prevail, the consumer could just run right to the bankruptcy lawyer, file bankruptcy. Not a very good investment for a debt buyer. So without trying to assume too much, my belief is if you raise valid defenses, you get those letters into that collection file, that when that collection file gets reviewed, there is a very strong probability that they will not send that out to a lawyer for litigation. So that's the first part of my book, is how to prevent the lawsuit from ever happening. Second part of the book involves defending the lawsuit. So let's say that by the time someone needs the legal information that the book provides, they've already been sued. Well, you have to file an answer. You have to raise affirmative defenses. Our courts are open to everyone. You don't have to be a lawyer. And in fact, the smaller cases are filed in courthouses where many of the judges are not lawyers themselves. They're what they call justice of the peace or a different type of judge that handles smaller claims. So by filing the answer, the defenses are preserved. You have to raise what they call affirmative defenses. I won't be lengthy on that now, but I have an entire section of practically every affirmative defense that I've ever raised in response to a debt collection lawsuit. And then the Debt Relief Playbook also has in the war chest sample answers that can be filed in court, and samples of those affirmative defenses. So once the matter's staged and those things are filed in court, again, there may be a counterclaim. I've got a sample of that in the book. The counterclaim is filed, and it must be filed in some instances if it relates to the same transaction or occurrence that's the basis for the lawsuit. Then if the counterclaim is not filed, it can be deemed waived. So all of that can be filed, and then there's a meeting at the courthouse. They usually call that a pretrial conference, where the lawyer for the debt collector is present and the defendant is present, whether they're with or without a lawyer, and the judge usually says, okay, go across the hall, see if you can work this out. If you can work it out, fine. If you can't, I'll set a trial. Well, there's dialogue that can happen there. You know, I don't believe I owe this debt. I want to see the proof. I want the validation. Fair Debt Collection Practices Act requires mandatory that they provide validation of their debt, and they can't move forward with a lawsuit until they do. The idea is by properly raising those defenses in the state courthouse or in the federal court, it's usually in state court on a debt, by properly raising those defenses, you avoid a default judgment. You're now in a situation where the lawyer representing the creditor knows they're going to have to see this all the way. Ongoing conversations will still take place between that lawyer and the debt collector or creditor. Is this worthwhile to fight this case to the end? So again, this is another opportunity to make a debt relief lawsuit go away. Finally, in the book, I dedicate a great amount of time in covering bankruptcy law. You know, in the event there are no valid defenses, or maybe there's just a lot of debt. A lot of people who come to me, we find out right from the word go that even if we solve this one problem, you've got other problems. And should we consider going into one court, one case, and eliminating everything, getting a fresh start through bankruptcy? Bankruptcy will discharge, we call it, will discharge or eliminate all debts of any kind with certain exceptions. So credit cards, medical bills, those type of debts can be completely eliminated. Of course, it depends on the income of the filer and some other factors like assets that you may or may not own. But it can provide complete elimination of certain debts, and bankruptcy can also provide reorganization of those debts that you need to keep and pay off. So we can lower car payments, we can lower interest rates, we can take a 3-year, if there's 3 years left on the car, we can make it 5 years. Student loans, you can get an automatic deferment on student loans for 5 years without making repeated applications over that period of time. And several other things that can take place through Chapter 13. Rehabilitating mortgages. In our district, we have a mortgage modification mediation program where we can force the mortgage lenders to sit down and work out an agreed modified mortgage with some reduced payment terms. The Debt Relief Playbook covers all chapters of bankruptcy, the do's and don'ts. Basically, in a nutshell, everything that I would include as part of giving someone an overall education on the relief that's available in bankruptcy, how you get there, and what chapter that you choose. The idea of the Debt Relief Playbook was to give all the information that essentially I would provide to a client, although each client that comes in to see me, they're at different phases, different things going on, and the book that I wrote was really a culmination of everything that would be reviewed and considered strategy-wise in order to eliminate the problem. And I encourage you to get a copy. It's available on Amazon. We have it on Kindle. It's at Barnes & Noble, but at Amazon.com you can just Google the Debt Relief Playbook. It's available through Apple and other locations as well. Thank you.